Good evening, everyone. We'll be getting started in 2 minutes at promptly 6:05 p.m. Thank you for joining us this evening.
Okay, we're gonna get started, 6:05. Good evening, welcome, and thank you all for joining the Family Law section of the Metropolitan Black Bar Association's The Pitfalls of Article 10, Part 2, Dissecting and Article 10 Abuse Fact-Finding. My name is Asia Scarlett Jones. I am the co-vice chair of the NBBA's Family Law section. I would like to thank the Appellate Division, Second Department for co-sponsoring tonight's event. At this time, I would also like to thank the Article 10 and CLE subcommittees for all of their hard work in creating this program, as well as our esteemed panelists and moderator for volunteering their time. This evening, you will receive 2 CLE credits for this program. Please be sure to listen out for the 2 CLE codes that will be announced during the program. I would like to also introduce the rest of our leadership of our section. We have Yvette Ennis and Ernestine Means, the co-chairs of our Family Law section, as well as my fellow co-vice chair, Celia Denman, and our secretary, Lissa Daly. Tonight, we have a very robust and wonderful program planned for you all. I can say from personal observation that the panelists and the moderator on tonight's program are passionate. They are passionate about Article 10 and making a difference. They are well-versed in the law and proceedings surrounding Article 10. And as a practitioner in family law, I admire judges, attorneys, caseworkers, the support staff, and especially tonight's attendees who have devoted their careers to helping families in need. I'm also grateful for CLEs like these, where we're able to gather and drink from the fountain of knowledge. I, like many of you all, will have my pen and paper ready during tonight's CLE because we are in for a treat. Without further ado, I would now like to turn the program over to Tanae McKinley-Brooks for the introduction of our esteemed panelists. Tanae?
Good evening, everyone. Thank you, Ms. Scarlett Jones. I'm Tanae McKinley-Brooks. It is my privilege and my honor to introduce our esteemed panelists tonight. I agree with Ms. Scarlett Jones that we are all in for quite an event, hearing from these accomplished attorneys. Yusuf El Ashmawy is a partner at Nelson, Robinson, and El Ashmawy, PLLC. Mr. El Ashmawy was born and raised in Brooklyn, New York. He is currently the head of the criminal and family defense practices at Nelson, Robinson, and El Ashmawy. He has extensive litigation experience, appearing regularly in criminal and family courts in all 5 boroughs. Mr. El Ashmawy is highly regarded as a litigator with extensive experience in child protective proceedings. Excuse me, he is presently working, my apologies. Prior to entering private practice, Mr. El Ashmawy served on the, let me start over. I'm sorry, my apologies, everyone. Mr. El Ashmawy is an experienced and highly regarded litigator with extensive experience in courts throughout New York City. Prior to entering private practice and serving on the assigned counsel panel, Mr. El Ashmawy served as a prosecutor of child abuse and neglect cases in family Court Legal Services Division of the Administration for Children's Services. He presently sits on the Family Court Advisory Committee and is the recording secretary for the Juvenile Justice Committee of the New York City Bar Association. Ms. Oates, Stephanie Oates, is the senior team leader and abuse specialist for the Administration for Children's Services. Ms. Oates began her career at Legal Services for the Elderly, Disabled, and Disadvantaged of Western New York, where she represented seniors on Medicare and Medicaid issues, landlord-tenant and housing code violation proceedings, and grandparents' rights in custody and visitation cases. It was there that she discovered she really wanted to practice in family court. In 2008, Ms. Oates began working with the New York City Administration for Children's Services. Presently, in her role as senior team leader and abuse specialist, Ms. Oates supervises multiple staff attorneys and team leaders in Bronx County Family Court. Grace Obama-Layat, presently serving as a staff attorney with the Legal Aid Society Juvenile Rights Practice in Bronx County, is an attorney who focuses primarily on representing children in child abuse and neglect proceedings in Bronx County. She has had also the experience of representing children who become parents involved in those proceedings as respondents. Ms. Obama-Layat has extensive experience in these proceedings, and her career is a natural outgrowth of her love for children and the belief that their voices deserve to be heard. Tiffany Wichman is the Bureau Chief for the Bronx Child Advocacy Center. Ms. Wichman is an Assistant District Attorney in the Child Abuse and Sex Crimes Bureau of the Bronx District Attorney's Office. Prior to her current position with the Bronx DA's office, Ms. Wichman was Deputy Borough Chief at the Bronx Child Advocacy Center. Before taking on the role of Deputy Bureau Chief, Ms. Wichman worked as an Assistant District Attorney assigned to the Bronx Child Advocacy Center, conducting forensic interviews of children on child abuse investigations and handling the criminal prosecutions. Ms. Wichman also spent several years with the Administration for Children's Services Division of Family Court Legal Services as an agency attorney and agency attorney supervisor, litigating and supervising Article 10 abuse and neglect proceedings in Bronx County Family Court. Finally, we have Maurice D. Williams, Esquire, founding member of the law office of Maurice Dean Williams. Mr. Williams has been a litigator in both criminal and family court in Westchester County. He currently manages a general practice firm that allows him to serve the indigent community as a member of the 18B criminal and family law panels representing defendants and respondents in criminal and family court proceedings. Mr. Williams is a member of the Attorney for Children panel representing children in juvenile delinquency proceedings, PENS proceedings, abuse and neglect, child custody, and family offense proceedings. Wow, that was quite a bit, but as you can see, we have quite an experienced and talented group of panelists for you tonight. And now I will turn it over to my my co-chair, my chair, Celia Denman. Thank you.
Thank you so much, Tanae, for a great introduction of our esteemed panelists. I am truly honored this evening to introduce our esteemed moderator, Judge Wayne A. Humphrey. Judge Humphrey was elected to the Westchester Family Court bench in November of 2019. In January of 2020, he was assigned to hear cases in White Plains Family Court. Judge Humphrey is presently assigned to hear cases in Yonkers Family Court, where he currently presides over matters involving juvenile delinquencies, family offenses, child custody and visitation, as well as guardianship matters. Prior to taking the bench, Judge Humphrey spent 23 years working in the Westchester County Attorney's Office. He ended his tenure there as the Assistant Chief Deputy County Attorney in charge of the Family Court Bureau. As such, Judge Humphrey's responsibilities included supervision and oversight of 30 attorneys and 6 support staff. During his time with the Westchester County Attorney's Office, Judge Humphrey became proficient in Family Court Articles 3, 4, 7, and 10, as well as Social Services Law 384B. Judge Humphrey had been responsible for prosecuting high-profile juvenile delinquency cases as well as child protective cases, including child sexual and physical abuse and child fatalities. He was the project manager for the Westchester County Child Fatality Review Team, where the mission was to investigate the child fatalities and recommend measures aimed to prevent future deaths of children. Prior to his employment with the Westchester County Attorney's Office, Judge Humphrey worked as an attorney of counsel in the office of Mays and Associates in Queens, New York. While there, he amassed vast experience in prosecuting and defending matters within landlord and tenant court, family court, and criminal court in New York City. Judge Humphrey received his Juris Doctorate from Pace University School of Law and his bachelor's degree in social work from York College of the City University of New York. He has been a presenter to numerous organizations, including New York State County Attorneys Association, Westchester County Black Bar Association, Westchester County Youth Officers Association, New York State Juvenile Officers Association, and various youth bureaus within Westchester County. At this time, I would like to hand the floor over to Judge Humphrey for some opening remarks. Thank you.
Thank you, Ms. Stenman. This topic is dear to my heart, not only the work experience that you've heard. At heart, my bachelor's degree was in social work. When I got out of school, my first job was to work in the foster care agency of St. Christopher's Ottilie, and thereafter at Abbott House. The work that we do in litigating Article 10 in abuse cases is paramount to protecting people's rights, protecting due process, ensuring that each and every child that comes through our systems are protected, and that parents' rights are protected also. What you'll hear tonight from all the presenters is that each and every one of us has an important role. An important role for the court, an important role for the litigants. To understand that this court is not merely going to push things through, but we are going to hear testimony, we're going to protect their rights and protect children. You as practicing attorneys have a responsibility, a huge responsibility. Not only does it require you to investigate, not only does it require that you develop a rapport with your clients, but it requires that you be able to paint a picture for the court. A picture which will allow the court to make a finding, which will allow the court to not make a finding. We as jurists should not have our minds made up. We as jurists should be able to hear the testimony and see the pictures that you're painting. As a prosecutor, as a defense attorney, as an AFC, your role is not simply to be in court, but to paint a vivid picture for this judge, a vivid picture that will allow us to make findings that are in the best interest of the children. As you've heard so far, we have an esteemed panel of very experienced people, and this is going to be a lot of fun. None of us are doing this because we're making a lot of money. We're doing this because we love the work. And if you don't love being in family court, then you shouldn't be there. I can tell you one thing, my experience through the last 25 years of working in family court and around family court, I went home every night feeling satisfied. Satisfied that I did the right thing, and that we're protecting people, protecting their rights, and protecting their children. There's never a dull day doing Article 10s. Never a dull hour. You will be able to develop complete expertise by doing the work. And what you're going to hear today is what the work is and how you need to do it. So thank you, Ms. Denton.
Thank you, Judge. At this time, we can begin with our first speaker, who is Ms. Oates.
Where's she at? I don't see her.
I'm here.
Okay.
Good evening, everyone. Thank you for having me on this panel. And I'm glad everyone could attend. So let's jump in, right? So the first thing I want to talk about is the types of abuse proceedings, the types of abuse cases. And there are really three. You have sexual abuse, physical abuse, and the third could fall under either sexual abuse or physical abuse, but it's the severe or repeated abuse. Sexual abuse is under Family Court Act Section 1012E3, and it involves allegations that a respondent either committed or allowed to be committed a sex offense against a minor, against a child, as defined in specific sections of the penal law. Those sections are outlined in the statute, and I know that 1012 is in your materials. The petition, when you see a sex abuse petition, it will list the specific sections of the penal law that are alleged to have been violated, and it has to list those sections because the court is going to have to make findings regarding whether or not the petitioner has proved a case saying that the respondent committed one of those sex offenses. Physical abuse is outlined in Family Court Act 1012E1 and 2. And those are allegations that a respondent inflicted or allowed to be inflicted or created or allowed to be created a substantial risk of physical injury by other than accidental means, a risk of death or protracted physical injury to a child. The other than accidental means part is key. The petitioner is going to have to prove that this was not just an accident, that someone either did something or purposely did not do something that led to the injury of this child. And it has to be protracted physical injury, not just that a child has bruising, but we're talking about broken bones. We're talking about serious, severe lacerations, things that are going to leave scarring, things that are going to leave long-term effects on this child. And then we have the severe or repeated abuse. And that is in Family Court Act Section 1051E. But 1051E refers back to Social Services Law 384B. And Social Services Law 384B is very long, and we're specifically talking about Section 8A 1 through 4 and 8B 1 through 3. So for severe abuse, the petitioner is going to need to prove that it was a reckless or intentional act of the parent or person legally responsible, but reckless or intentional acts of the parent committed under circumstances evincing a depraved indifference to human life, which results in serious physical injury as defined in subdivision 10, section 10 of the penal law. If it's severe abuse alleged based on a sexual abuse, they must have committed one of the felony sex offenses. Again, they're outlined in the statute, but specifically Penal Law 130, 25, 30, 35, 40, 45, 50, 65, 67, 70, 75, 80, 95, and 96. All of this is outlined in Social Services Law. The parent must have been convicted of murder in the first or second, manslaughter in the first or second, and the victim was another child of the parent or another child they were caring for if they were a person legally responsible for that child. the agency has to show that they made diligent efforts to strengthen this parental relationship between the child that is alleged to have been severely abused, unless there is a finding that reasonable efforts didn't have to be made. Now, that is going to be via a 1039B motion, which I'll discuss a little bit later.
So, Mr. Oates, I had
For
a couple of questions. And what I'd like to first begin by asking you is, it sounds like the most important part of you initially drafting those petitions is reviewing the statute.
Absolutely. Because when you're drafting this petition, if you don't know what it is that you are required to prove, if you don't know what the elements are for each of these causes of action, your petition is going to be deficient and you're not going to be able to proceed. So there's,
go ahead.
Yes.
You continue.
Yes, so you absolutely have to review the sections of the relevant sections of the statute, review the elements for each of these causes of action, and make sure that the petition includes the information necessary so that you can prove the case.
So then I think that what we as practitioners need to know initially is, as we're drafting these petitions, as we're defending these petitions, we need to refer back to section 1012 and 384 to understand whether or not the prosecution has met their burden and how we're going to paint that. So my next question for you is, once you've reviewed the statute, how are you proving those various elements that you need to establish based on the statutes?
So of course, it's always, a lot of this is very fact specific, right? So if your petition, I'll use the example of a physical abuse petition. If you have a physical abuse petition that alleges that a child suffered fractures or some sort of subdural hemorrhaging, internal bleeding, some sort of physical injury in that manner, each of the allegations, for each of the allegations, you're going to have to look at what you need to prove that. If the child has suffered a fracture, then you know that there's going to be some sort of medical record that you need, or some physician that you need to testify, to the nature of the injury, that fact that the child actually had a fracture, and the mechanism for the child sustaining that fracture, right? Potentially, again, depending on the allegations, you could need a number of medical experts in one physical abuse case. If it is an abusive head trauma case, where you now have a child who potentially has fractures, has subdural bleeding, has retinal hemorrhaging in the eyes, that kind of case is going to require a radiologist for the imaging that was done on the child, to talk about the fractures that are shown on those imaging. It's going to require an ophthalmologist to talk about the retinal hemorrhages that the ophthalmologist saw in the child's eyes. And it's going to require potentially another child abuse expert, another doctor who can tie all of that together. You have each one of these doctors, each one of these experts are going to talk about what they know in their specific part of the body that they deal with, and the mechanism for sustaining those injuries. But you still need someone to put it all together and say, this constellation of injuries is indicative of child abuse, right? If it's a fatality, where unfortunately we have cases where children have died, you probably will not need every single one of those experts, because the medical examiner who did the autopsy should be able to testify regarding the entire constellation of injuries, because they will have done the examination on the child and seen those injuries themselves, each one of those injuries.
So for what I'm hearing from you, as your role as a prosecutor, you have to learn medical evidence, understand the medical statements made by doctors, understand how to establish something's intentional versus accidental. So it requires not simply that you listen to your caseworkers, but you have expert opinions made by physicians, radiologists, ophthalmologists, medical examiners to help you prove your case. Is that correct?
Entirely correct. Of course, you have the statements made by the child, if there are statements that are made by the child, there's statements made by the parents, if there are any, and your caseworker can probably testify to a lot of that. But if there are serious physical injuries in the case of a physical abuse case, you're going to need someone more than just your caseworker. And then in the terms of a sex abuse case, then you can have the statements of the child, but then you run into corroboration issues. If you don't have any corroboration for the child out of court statements to the worker or to another individual regarding what happened to them, then you're going to actually have to call the child to testify to what happened to them, which is something we try to avoid because it's a traumatic experience to begin with. Nobody really wants to have to put a child on the stand to relive anything that's happened to them or is alleged to have happened to them. But sometimes it's necessary. So in addition to knowing having some knowledge base regarding the medical side of it, you actually have to have empathy and some sort of ability to be emotionally connected in a way to what a child needs and is going to be able to have to go through in court and in testifying regarding any of this.
So I think
there are
that
so many different.
Excuse me. So when you're when you're looking at the sex abuse cases, I know you have the statements, the out-of-court statements of this child. That generally has to be corroboration, some type of corroboration. That corroboration could be physical evidence. And does your agency also use sex abuse evaluators or validators to be able to establish corroboration also?
We do use validators if there's no other, if there's no physical evidence, no other witness to it, no admissions or statement that could potentially corroborate what the child has said, then the agency, the presentment agency can and does use validators. An individual who will meet with the child a few times and have conversations with the child and is able to provide their expert opinion as to whether or not the child's statements and behaviors are consistent with a child who's been sexually abused. We tend to use validators in instances when the children are young, very young, and aren't able really to articulate very well what happened to them. But yes, we do use validators. We also utilize the Child Advocacy Center, where the child is seen by a forensic interviewer, and it's more of a factual, kind of neutral situation where the child is saying, exactly what happened to them. So it's their it is the child's statement as being told to someone who is trained in interviewing children regarding abuse and neglect.
And what if any of the pitfalls you have with using validators?
So the thing about the validator is it's still someone's opinion as to whether or not a child's behavior and statements are consistent with being abused, right? And I think it makes things come into question just as with any other expert, because there are counter experts who could say this child pointed to a doll during the interview with the validator, but maybe they were guided that way. Those are the kinds of arguments that could be made. Maybe they were guided that way, or maybe the child wasn't really pointing at that. And as with, I think, any expert opinion, There are ways that opposing counsel can pick away at it. Whereas the child, a factual statement from the child is a little bit harder, I think, to pick apart.
So my next question to you is regarding those out-of-court statements, and are they admissible as proof in court?
The out-of-court statements of a child, yes, are admissible as proof in court. They just have to be corroborated. And it can be anything that tends to corroborate the statements of that child. We can have a situation where a child says that a respondent sexually abused them in a hotel, or and another individual was present and they had all gone to the store prior to going to this hotel, for example. And the respondent could have said, we went to the store prior to going to a hotel, but there was no sexual abuse. That is, in my opinion, and I would argue, does tend to corroborate what the child says, even if it's not every single detail that the child provided. There is corroboration there, and I don't think you don't have to have every single detail corroborated. It's anything that tends to corroborate the child's statement.
And could you tell me about any or how you've collaborated with the district attorney's office, and I guess that's Ms. Wichman, and how do you both work together on those cases that one may be in family court and one may be in criminal court?
Right, so that happens fairly often. And we'll have situations where our cases are going at the same time. Maybe our family court case will go to trial prior to the criminal case going to trial. And we do try and let the criminal court, the district attorney's office know, and the ADA who's handling the case know, if we're going to trial, these are the dates that we're going to trial. If you want to come and sit in, you can come and sit in. And I know opposing counsel, it's the same for them. I mean, if their client has a criminal case and the criminal court attorney wants to come and sit in when the family court case is going to trial, they can come and sit in as well, because it gives you it gives you a heads up as to what the testimony is going to be or could look like in the criminal case. We try not to have to do interviews repeatedly. And I know Tiffany's going to talk more about the CAC and what happens there. So
that's a perfect
in that respect.
So let's transition to Ms. Tiffany Wichman, who's from the Bronx District Attorney's Office. Ms. Wichman, why don't you tell us what is a CAC and what's your role at the CAC?
Sure. So prior to working here at the Bronx District Attorney's Office, I was actually working at the Bronx Child Advocacy Center directly. And those are two different roles, both working with the CAC. CAC is just, it's a commonly used shorthand for child advocacy centers. They're statutorily prescribed. So Section 423A of the Social Services Law really outlines what a CAC entails, and it directs that they exist and be used in every region of New York State. It's really just...
That statute's quite clear in that it tells us what it should look like. I guess user-friendly. It should be a collaboration, and we just spoke with Ms. Oates, and part of that is a concurrent joint investigation. Is that correct?
That's right. So the CAC itself is just a site where, you know, the various players in any child abuse investigation are either permanently co-located or they temporarily come together to meet on these types of investigations. So we're talking about like an actual office space that houses the different government agencies. nonprofits, medical suite, mental health treatment on site. And the idea is that all aspects of both the child protective child abuse investigation and a criminal child abuse investigation can occur in one location to make it easier for the child.
And
And to make
why do we think that's easier for the child?
so prior to CACs, child abuse investigations could be very disjointed. A kid may be interviewed over and over by the person they made the disclosure to, by school staff, by the police when they respond to the 911 call, by a specialized detective, children's services. It goes on and on and on. And I think the research says that before CACs, the average was about 10 times that a child would be interviewed, right immediately, one after the other. And so, that there was a lot of research done about whether that was trauma informed in any way, and it really wasn't, and it didn't lead to good investigations because any child put in that situation tends to shut down, and it just re-traumatizes them in a way. And so, in response to that, first there were some hospitals creating programs where at least they'd have child-friendly spaces, properly trained physicians, and that sort of evolved into this push by national nonprofit organizations to create child advocacy centers. When that made its way to the New York legislature, they created the social services law, and also it's codified in the executive law too. Section 642 says, this is the best way to handle any of these types of investigations. And so this is the way that we want to do it here in New York State. And there are CACs all over the state. In New York City, there's one in each of the five boroughs. Upstate, they're either county specific or a group of counties together. And I've even heard that in some of the more rural areas in the state, they have mobile CACs that are trailers that sort of bring the people to the child, or close to the child in any way that they can. And at least, what I've seen over the last 10 years that this has really been happening in New York City is huge changes in just the way that there's communications between the agencies, the way these investigations are handled. They're hopefully easier on the child, but also faster, which can be important if you're really trying to get to the bottom of what happened or didn't happen. And I mean, part of what 423 says as well is like the types of cases, right, that should go to a CAC. Each local district in New York State is allowed to come up with sort of the types of cases that will be handled by their team at their CAC. But the emphasis is on investigations with any allegations that meet the criteria of Section 1012E of the Family Court Act. So any physical abuse or sexual abuse of a child for purpose of Article 10 proceedings. That's the emphasis of what should go to the CAC. In New York City, the general criteria has been allegations of sexual abuse of a child less than 13 and investigations involving physical injury to a child less than 10. What level of physical injury that child needs to have can vary, but generally any injury that rises to the level of being investigated criminally. And the way it starts is that there's this call to the child abuse hotline to the state central registry. That substance of that call is immediately screened to see if it meets criteria. If it does meet this criteria, it's sent directly to Children's Services and law enforcement. They're alerted simultaneously. And the expectation is that there will be a joint response, or at a minimum, joint communication about how the response will happen. And if that child lives with the person that's being accused of abusing them, the goal is to have them immediately brought to a CAC. If the situation is less urgent because that person being accused is not regularly in their life every day, it might be scheduled and planned out a little bit more, but the idea is that it happens right away so that there isn't this repeated interview at various places by various people. Cases can be referred that don't involve criminal investigation, but that's typically the exception. That decision is usually made sort of on a case-by-case basis. And referrals of children can happen after Article 10 cases are filed in family court if they haven't already. There's references to this directly in Article 10. Section 1034 talks specifically about children's services, asking a judge to direct that a child be produced by a parent for an interview at a CAC. So for instance, if that is the goal and a parent won't produce the child, there is a mechanism in the Family Court Act to get that brought before a judge and have a judge make that decision. And there's
So,
also
Ms. Wichman, so at your CAC, are those interviews recorded?
they are. So what's going to happen at the CAC once the child is there is, the multidisciplinary team members are going to meet, and there's going to be a discussion about the allegations and also, who's the best person to do the interview. The idea is that one person be in the room with the child and that the rest of the team members be sitting in a separate observation room. And at the New York City CACs, those interviews are video recorded and they're also live streamed to the other team members, so that there's only one person that is forensically interview trained sitting in the room with the child so as not to overwhelm them. Typically in New York City, that will be a social worker from Safe Horizon, who is the nonprofit organization that sort of runs a lot of these sites. And the idea behind that is that they might appear as the most neutral party. The other organizations are trained. The attorneys are trained. As an assistant district attorney, I've done some of the interviews myself, if there's a specific reason to do that in a specific case. But the rest of the team members are just right there in the other room watching it through this video so that they can put in the questions that they might need to have answered as well. The second thing that typically happens, at the Child Advocacy Center is the medical exam. So there is, or there is the goal, at least at every CAC, to have a medical suite on site. And that medical examination by a trained physician can be for physical abuse or for sexual abuse. Most CACs, their physicians are qualified to take sexual assault evidence collection kits. They can do blood testing, they can do urine testing, they can send out for laboratory testing, they can give prescriptions if needed. And really the only thing that typically can't be done unless you're in a hospital-based program is radiology. So the New York City CACs do have to send kids to hospitals for any type of scans, but otherwise the exam can be done on site. And again, the idea is that even that medical professional doesn't need to ask a lot of questions of that child because they have all of the information right there. And the child doesn't have to leave and go to yet another place to, drag this out and talk about this even more. They can sort of remain in this one space and everybody there is helping them in whatever way they are involved in this investigation.
So my next question is with that, is there a report produced and is there a video produced, and how is that shared, if it is shared with counsel that may be your adversary?
Sure. So the video recordings, a copy of them are typically given immediately to law enforcement and are also maintained by, in New York City, it's Safe Horizon, but whatever agency is running the actual site will maintain a copy. I know, in New York City, Children's Services or Children's Services Division of Legal Services can then request a copy from, the nonprofit from Safe Horizon and obtain that copy and share that copy with opposing counsel, with attorneys for the children. Typically, we ask for some sort of protective order. The child can be talking about pretty sensitive things, and we don't want this video ending up in other places and being shared outside of the immediate people that really need to see it. But the goal is that interview itself, that recording, could be played in court at a trial so that everyone can see and the judge can see the child describing this for themselves. The other thing that sort of comes out of this, obviously we have this medical exam, and so there are going to be medical records. The medical records could have some version of notes or report from the physician about what they have found, what the diagnosis is, and in a physical abuse case, whether they believe this to be consistent with the explanation or consistent with an accident, or they believe the injuries are inflicted. The New York City CACs do not hand out, aside from what's in the medical records, they don't hand out a specific report that would detail everything, or some sort of, an evaluation that gives you a finding at the end. What their sort of goal is here is the actual statements by the child on recording. You can see it for yourself. And here is the medical exam and those findings that were made by a medical expert. There are a lot of hospital-based programs that still exist that will do more of a report. And I have seen, in other places in New York State or outside of New York State, something that's more report looking. But most places, if they record the forensic interview, what you're actually going to get are the recording, and then if you need them, the medical records.
So other than the investigation, what services are offered to the family members that come through the CACs, if any?
Right. So there should and has to be, really based on the social services law, some form of mental health, or counseling or victim advocacy on site. And the reason for that is that obviously all of this can be traumatic, not only for the child that's talking about it, but for their siblings, for their caregivers, and for the rest of the family that might be involved in whatever way in what's going on. And the in New York City Safe Horizon staff, or elsewhere, it might be a different organization, they have trained social workers who, number one, can meet with the family ahead of time so that they know what the process is and are prepared. And then after, can debrief with both the child and the parent together or separately to ensure that, everything is okay, that they're stable before that they leave. They also teach coping mechanisms to the child. This can be traumatic, it might keep coming up. Here are some ways you can deal with that. And to the parent, here's how to recognize if your child is struggling or having a traumatic reaction, and this is what you can do. They also offer usually short-term types of crisis counseling on site. So programs that last a number of weeks that are geared towards handling the immediate reaction to this trauma and this crisis, and then providing referrals out to other places if a child or a family member needs something more long-term.
So let me say that we've come a tremendous way as being empathetic prosecutors and investigators on these very serious cases. Early on in my career, what we saw was children being repeatedly interviewed by police officers, by CPS, by school officials, and then by their defense attorneys, and the family not getting any services. And what I've just heard from you, Ms. Wichman, is that early on, everyone that's involved in these investigations are getting what they need to be able to protect children, to be able to prosecute cases, be it from the ACS perspective or from the district attorney's perspective. Being able to provide services through victim assistance, to be able to provide mental health services, and more importantly, be able to provide the child with appropriate medical care immediately. If there are broken bones or if there is some sexually transmitted disease that they may have caught in the process of whatever may happen in the fence. And why I say we came a long way is because now we know that this is centered around the victim, and centered around the victim and ensure that they're protected as we go forward. Do you have any closing remarks?
No, only to say that Now, like I mentioned, I'm an assistant district attorney, but I've been on the family court side of this as well. And one thing that's really important to remember is that any abuse case that you have, there is this potential for this concurrent criminal investigation and case. And even if there hasn't been an arrest and a criminal prosecution, there was law enforcement involvement and possibly the involvement of the district attorney's office. And it is really important. I know Ms. Oates, had talked about how we tried to communicate about what's going on. It's really important to know that this is out there and that this communication is not only happening but is required by statute. And so there are going to be these other records, this other evidence, these other agencies that have interviewed people in this family that, you're, regardless of what side of this case you're on, you're going to want to look into and you're going to want to have those conversations.
Yeah, and what the CAC has done is we've taken us out of our silos, and we're all working in the same areas, and that open communication is requisite to protect our children. So thank you. So Ms. Layat, are you ready?
I am.
So tell me about what is an institutional provider?
Well, an institutional provider is somebody who is basically backed by an institution. In my case, the Legal Aid Society. I work as an attorney for the child within the institution of the Legal Aid Society's juvenile rights practice. And I think that a huge advantage is just having that institutional support in representing the child in the neglect, abuse, and other proceedings. We're able to offer them, as a result, very focused and all-inclusive wraparound services, if you will. Unlike 18Bs or panel attorneys, we can immediately refer a child for mental health services. We can immediately meet with a school if a child is having an issue. We represent them beyond just the court case, and we're able to do that on a very, I would say, on a micro level, just really supporting the child and his or her needs. We do work as an interdisciplinary team. We have paralegals, social workers, investigators. We have an education advocate who work with our clients just to make sure that all of their needs are being met. At the inception of a case, when we are assigned, the very first thing we do, usually with a social worker, is to review the petition and to identify immediate needs for the child or children, to also identify potential conflicts in representing the children. And if we do identify a conflict, we will ask the court to assign additional attorneys for children. If that is not necessarily clear on its face, then we will speak with the target child or the target children to get a sense from them as to whether or not there is a conflict. And we trust that our clients would be able to articulate that to us so that we can best navigate our representation of their needs.
Thank you, Ms. Obama-Layat. I apologize, Judge. We just have to announce the CLE code.
Sorry.
The first CLE code for this program is CAC. CAC is the first CLE code for this program. Thank you.
I did want to comment very briefly on one of the things that Ms. Oates was discussed, which is the child, when the child is called to testify. I think that that is a place where we, as the attorney for the child, are able to provide that child a lot of support. First of all, once the client has been subpoenaed, we speak to our client, we meet with our client and ask them if they feel comfortable testifying. Sometimes they do feel
comfortable testifying in open court. Other times they may ask for CCTV testimony because they don't want to have to be in the same courtroom with the respondent while they're testifying. And other times they may say that they don't want to testify. And based on their response, we may file motions, maybe for an in-camera testimony or the CCTV testimony, or we may say that their testifying would be contraindicated to their mental health. And in that case, that would be supported with a report or statement affidavit by their therapist, assuming that they are engaged in therapy. When they do choose to testify, we work with ACS to schedule witness prep, and either myself or the social worker will always be present with the child as they prepare to testify. And we will stay with the child up until the moment that they are on the witness stand. Some of them ask for stress toys. So I did have a client who needed some little stress toys so that she could, testify and sort of work out her nerves. That's something that my office was able to provide her.
So my question is, as an AFC, how do you decide which child do you think should be able to testify, other than, based on an opinion of a clinician?
Well, ACS oftentimes will need our client's testimony in order to prove their case. And when that happens, we have a conversation. I will have a conversation with my client. I will let them know that, unfortunately, because there is no corroboration, for example, it will be necessary for you to testify. And, I have had clients who have reluctantly agreed. And then depending on the amount of time before the fact-finding date, I will work with that child. The social worker will work with the child. We'll also speak with their therapist to see how to best prepare the child to testify. So it's not necessarily my decision, it's what's necessary to prove the case.
And my next question is, have you thought of unique ways for the child to testify? Are you seeking in-chamber testimony? Are you doing closed circuit testimony? Are we asking that the respondents be outside the presence of the child? What efforts have you made to have it look a different way rather than a regular courthouse?
Oh, that is exactly what we do. Once the subpoena has been served on my client, I meet with my client, we discuss the subpoena, we discuss what it means to testify. And based on that discussion, I will file papers for CCTV testimony. I will file for whatever it is that they would need in order to be comfortable testifying. So it is definitely client-driven. And then my role as the AFC is to advocate for their position in terms of testifying.
And is it ever necessary for you to obtain mental health records or educational records of your clients?
Legally, there are times when they're necessary, but as a rule, particularly with mental health records, we resist having their mental health records brought in as as evidence, because it is sensitive for any person who's engaged in mental health services to know that their records might be made public in some way. So we generally will file a motion to preclude their mental health records. I've had judges rule both ways in denying my motion or granting my motion. Judges also will tend to order an in-camera review of the mental health records to determine whether or not there are any statements that the child has made regarding the abuse and the allegations in the petition. And if that does occur, then the rest of the record is going to be redacted so that just those statements would come into evidence.
So could you tell us what an in-camera review is and how is that used in the proceedings?
I'm sorry, I didn't hear the last part of your question, Judge.
And how would those records that were reviewed in camera be used in the proceedings?
So generally that request for the mental health records tends to come through the respondent. And in camera review, the court will receive the mental health records and review the records within either the judge or I assume the court attorney, and then we'll make the determination as to whether or not there are any parts of the mental health records that would be relevant to the proceedings. And then whatever is relevant would be, well, what is not relevant would be redacted, and the balance of the records would be admissible as evidence.
Now, we heard from Ms. Wichman about the CAC process, and we heard from Ms. Oates about a collaboration that may occur between the District Attorney's Office, the ACA's office and the AFC panel and yourself. Are you involved in those CAC interviews?
The Legal Aid Society is not involved, so we would just receive a copy of the recording of the CAC proceedings, where, again, yes, we're not involved. We do have a lot of contact with the ADA's office, and I personally, especially if my client is seeking to go forward with the criminal court case, I will collaborate with the ADA's office in terms of apprising them of what the proceedings, the status of the proceedings in family court. There are times when the child needs to be brought in to witness prep or just to talk to. Sometimes my clients would, ask that a social worker from our office at least accompany them and wait with them until they speak with the ADA. There are times I had a situation once where I went to the criminal court proceeding, and the public defender made a statement that was entirely false, and I was there, so I was able to note my appearance and and inform the court in terms of as to what had actually transpired. I have also helped in drafting a client's victim impact statement and having that read in the criminal court when the defendant had pled guilty, basically. So I work with them. I actually also have assisted with getting a criminal court order of protection that is not subject to family court changed and modified to be subject to family court based on my client's desire to have supervised visitation with the respondent. And that, I think, was effective because of my prior relationship with the ADA, who was concerned that there might be some witness tampering, but in speaking with her, I was able to reassure her that that would not be the case.
So what happens when you and the ACS worker and prosecutor are not able to get along, and you have adverse positions? How have you dealt with those situations?
Tactfully.
And tell us how you do that tactfully.
With humor. Yeah, sometimes it can get a little heated, but just personally, I tend to be a very calm person. So I just do my best to communicate what my client's wishes are. And I may find that I'm not able to have a conversation with an attorney just because we are so opposed in our positions. And if that happens, then at least they know where I stand.
So what I'm hearing from you today right now is that really you're client-centered, and
Absolutely.
your positions are centered around positions taken by your client.
Absolutely. It's a matter of truly listening to your client and even just reading between the lines, because they may say something to you or to another person that's different. And it's reminding them that my job, my goal, the only reason that I am in their life is to advocate for them. And one of the things that I see with so many of my clients is they tend to blame themselves for a lot of the abuse that they experience. They somehow think it's their fault, that somehow they're bad. And it is my job, and it is something that I take very seriously, to remind them that they are children and that the abuses that have been perpetrated against them have been by adults who have made those adult decisions, and it is not their fault. And I often remind them that had the respondent perpetrated the abuse on a stranger, that there would be criminal prosecution. So I really do try to instill that in my clients, as well as reminding them that in spite of all that, they can still love their parent. Like, they're not mutually exclusive, because they're very conflicted oftentimes.
So guys, what we've heard so far from the first three presenters is that each party has a role to paint. And based on the prosecution, the district attorney's office, and the AFC, as I look at Ms. Layat's background, everyone's got a different, unique part of the picture to paint. And that picture is centered around our children. And sometimes what we've learned with the CAC process is that this collaboration allows us to create moettes like see behind Ms. Layat. Those pictures are unique for each and every case, and is detailed based on a collaboration of speaking to our clients, by listening to our clients, by becoming experts on evidence, medical, and how we can move forward. We can only do this by the dedication that each one of these ladies have expressed to us today, and their passion in doing this work, in painting a clear picture for the clients, but even painting a more clear picture for the judge, so that the judge can make a decision. Not easy work. We've just spoken for about an hour and 15 minutes. And this is just the real beginning of how we represent clients through this process. And what we hear is that this is not about the judge. This is not about the next win that we have attorneys, but this is about the people that come through this process and protecting their dignity and protecting their rights throughout this process. And now we get to hear from Mr. Williams, I believe is next, who will be painting a picture of us and maybe taking away some of the flowers that have been painted. And his role as a 18B attorney is to change that picture. You know, and what we know as we move through this process, we have certain roles. And the prosecutor initial role is to present a prima facie case. And once that attorney has made that prima facie case, now it's incumbent on defense counsel to be able to do their part. And their part is to make a defense. So Mr. Williams, as the AFC, tell us what, Mr. Williams, you're doing the AFC or 18B for us, sorry.
That's correct. I'm doing AFC. I know oftentimes I wear different hats, but today I'm going to be talking from the perspective of an AFC.
All right. So
and first, let me say thank you. Go ahead, Judge.
I'm sorry. So I jumped ahead. So Yusuf, that's going to be for you later. All right. What we did here is we heard from the institutional provider. So could you tell me how are you different from the institutional provider as a sole practitioner AFC?
All right, so first let me say thank you for giving me this opportunity to take part in this discussion. You know, I have been asked to opine on my role as an AFC. And this is something that I really hold very dear. and I take much pride. Judge, I've appeared before you. Hopefully you can be a witness to my advocacy, and this is something that I hold very dear to my heart, my work as an AFC. I'm also on the 18B panel, but I take more pride, much more pride, and I'm excited about representing children and helping children. Now, I have been asked to opine on the role of an AFC. I joined the Attorney for Child panel just when the rule changed. Formerly, it was referred to as a law guardian, and you would be guided by what's in the best interest of the child. I believe that was in 2007, is when the rules changed, and attorneys, and it was changed from law guardians to attorneys for children. And our role as an attorney for a child, what I learned was that I have to zealously represent the child as I would any other client that I had. And oftentimes a lot of attorneys struggle with that concept, which I don't understand. I don't get it. But it is what it is. You have to represent your child client as you would any other client. And you have to be guided by Rule 7.2 of the Rules of the Chief Judge, where it basically says that if the child is capable of knowing, voluntary, and considered judgment, the attorney for the child should be directed by the wishes of the child. Full stop. Right? Now, even if it's a situation where you don't necessarily agree with where the child is coming from, and that often arises in the concept of a fun parent as opposed to a strict parent. Unless there's a situation where the child lacks capacity for knowing, voluntary, and considered judgment, then you have to go with what the child says. Unless the child there's a risk, of imminent harm to the child. And the problem arises because we all have our own preconceived notions of the role of a parent, whether and the relationship between a parent and a child. A lot of individuals have an idea that a girl should be raised by her mother, a boy should be raised by his father, and that plays into how individuals advocate, and honestly, that has no part in your advocacy as an attorney for a child. You have to advocate zealously for a child, irrespective of what your preconceived notions are of what where the child should be or who the child should be with.
So what I hear,
go ahead, Judge,
is that we've moved away from the paternalistic aspect of having kids in court and representing them without their voice. And what I hear you saying is that voice of the child is paramount to your role as a litigator for that child.
That is correct, Judge. And our role as an attorney for the child is to help to protect the interests of the child and to help them to express their wishes. What I tell my child clients is that I have to be the best you that I can be in court. Right? You're not going to come to court except for in an instance where a judge wants to have an in camera. But I have to be you. So I have to, in terms of my ethical obligation, I have to reach out to my client. I have to speak to my client. I have to be one with my client. So I can come to court and I can say, Judge, this is what my client wants. I have to advocate for my client zealously.
So, let me just divert a little bit here, because I've been doing a lot of work with some of our youth. And some of our youth, I talk about kids that have been in foster care and through the juvenile justice process. And one of the biggest concerns that they have had with the AFC panel throughout the state is they only see their attorney right before court.
Right.
And it's a complaint that we've heard from the brave hearts, from children that come into court. How do you foster that relationship with the child to let them know and realize that you are their attorney and that you're going to represent their interests zealously?
You have to have a bond with the child. I can tell you, for example, still getting accustomed to my glasses. I know some of you are wanting, never seen you in glasses before. You know, I've had situations, especially in the era of Zoom, where you'll talk to a child on Zoom. You send a Zoom link and you talk to the child. I've had situations where a parent has said to me, and I realized I've picked up the child as being a bit shy with the camera. And I've spoken with the father, and I've asked the father or the parent, and I've said, what's going on? Does the child want to see me in person? And in that situation, the scenario I'm making reference to right now, I left my office. My office is physically located in the Bronx. I'm a Westchester attorney, but I jumped in my car and I drove to Yonkers to see this child in the rain. And it was a completely different child from the one who I was seeing on the screen. So, you have to, every situation calls for a different approach. There are some kids who don't necessarily want to see you. They don't necessarily want to see you in person. They don't necessarily want to see you on the video. When they get to teenage years, you got to talk to them on the phone. From my approach, I have 3 children. So, oftentimes I'll have a child who is, say, 15 years old, and my daughter is say my daughter is 10. I'd say to that 15 years old child, to break the ice, tell me about 15. What should I expect at 15? And that oftentimes allows us to start that conversation, because again, I can't zealously represent this child if I don't know exactly where this child is coming from.
So as you, with this issue, we're talking about Article 10s and abuse and neglect cases. What are the first critical steps you need to do when you're litigating these type of cases as an AFC?
Well, the first critical step is to find out exactly what happened. How I approach my cases is that, in a situation where you have multiple children, I would interview each child individually. I would talk to each child and I'd explain to them. First, I'd maybe talk to the parents. If the child's with a parent or with a foster parent or a caregiver of some sort, I'll give them a broad analysis of what my role is. Then I would speak to each child individually to find out from them, okay, what is going on and how can I best address your needs. By adopting that approach, what I have found is that, like for example, recently I had one case where 2 children want to see the dad. One child didn't want to see the dad. So I have to figure out, okay, how do I approach this now? It's not a situation where we're trying to determine whether or not the child should reside with the parent. It's really about contact. What kind of contact? Visitation, unsupervised. Do you want to see your dad in a supervised setting? Do you want to see your dad or your mom, as the case may be, in an unsupervised setting? You have a situation where you have secondary trauma, where a child may have witnessed the abuse of another child. I had a situation just recently where there are 2 daughters and 1 son who is autistic, and the dad could not understand why this autistic child is not functioning at the level of the daughters. So he would beat on this child, on this little boy, and that little boy didn't want to have any contact with dad. The daughters, they wanted to see him, but they would prefer if somebody was there with them so that they could feel safe. In that same situation, I'm not sure how Your Honor handles that. I'm not sure if there's a bright line in terms of conflicts when you have siblings in that situation. But I have seen in my years of practice, I have seen situations where a judge will tell you, or you choose which child you want to represent. I have seen situations where judges have said, if you disqualify us to one, you disqualify us to all. In the situation which I explained just now, I was actually, we were before a referee, and the referee told me that I could represent the two children, the 2 daughters, and I didn't have to necessarily represent the son. So now the question in my head, is there a conflict? Now, to address that issue of whether or not there's a conflict, you have to go to the reconciliation of the question, which I started out initially with. Can you zealously represent this child? If the answer is no, then if you conflict as to one child, you conflict as to all. If you cannot zealously represent the child, then you cannot go forward. I believe that is the bright line that's a bright line that I go by.
I think the conflicts is an issue that very often happens with how we assign AFCs and matters, because generally we don't, with sibling groups, we assign one, and we then eventually will have the conflicts and we have to figure out what's the best way to work. And luckily I haven't had to deal with that just yet. How do you decide what type of case you want to put on in an Article 10 case, and what evidence would you want to put forward after hearing the case from the prosecution and the defense?
It depends on the direction that the case is going. As I indicated just now, in the context of Article 10, oftentimes, and I'm sure Joanna has seen it, and the other attorneys on the panel, other attorneys who are here as well listening in. I'm sure you've had situations where the child actually wants to be with the abuser. We're not necessarily talking about sexual abuse. It could be physical abuse, where the child has been abused, but the child still yearns for the love and affection of that parent. So the question is there imminent risk of harm to this child? And if so, again, going back to my initial thoughts, you have to zealously represent the child. However, and you have to zealously represent the child's position. So in a situation where the child wants to be with the abuser, the question is there imminent risk of harm? Is there a high likelihood that this child will be placed in a situation where this abuser will continue to abuse this child? And in that situation, what you have to do is that you have to put on the record, Judge, this is what my client wants. This is what my child client wants. However, I believe that there's imminent risk of harm to my child client. And as such, I am using substituted judgment. And based on my substituted judgment, my use of substituted judgment, this is the direction that I believe that the case should go.
And that substitution of judgment has been created by the change in what your title is versus being a law
That is
guard
correct, Judge.
versus being an AFC.
That is correct.
At least from what I hear from the AFC panel and what I've seen throughout the years, substitute judgment occurs rarely. Is that fair to say?
It does, Judge. It does. It does. Because again, as I said, you have a situation where oftentimes these children gravitate towards the abuser because the abuser oftentimes is the one who actually is a source of nurturing. And they may have been abused when they were younger and the cycle continues. That's the only way that they know how to express. So it's important that this person is put in a position. And that's where, when you come into services, you try to advocate for the services, for services to be in place so that ultimately what your child client wants, they're able to get that. And in terms of, so the question is, do you put on a case where you try to nail this abuser to the wall? Maybe you have to. Maybe you have to, but if you're doing that, using substituted judgment. Or is it a situation where you can work with the county attorney, and you can work with the parent? Tell the parent up front, you know what? I am not your attorney. Nothing that you say to me is confidential, but this is what my client wants. Maybe you need to try to see if you can work on getting these services, because my client really wants to be with you. And this is how we can get you there. If we can't get you there, then unfortunately, I am going to have to be in a situation where You know, I may have to put this child on the stand, which honestly, I don't necessarily like doing, because you have to weigh, is this going to result in long-term issues as far as this child is concerned? Because in a situation, I'm sorry if I'm being long-winded. I'm sure you've heard me say that so many times, Judge, about me being long-winded. But, you know, in a situation, in a situation where you have a child who is young, and this abuse may have happened some time back, it may be so far in the recesses of this child's mind. Do you really want to put this child on the stand for this child to relive through this trauma? So these are the things that you have to consider when you're making a determination as to whether or not you want to put on a case, so to speak.
So I had two brief questions. The first one is, when you do that substitute your judgment for a case, are you announcing that to the parties and to the court so that they're aware that that is something that you're doing?
You have to. You have to. And in fact, you know, this has been a bone of contention for me, being as an 18B attorney, where I have seen attorneys, AFCs, substituting judgment and not announcing it to the court, because, you know, they have their own preconceived notions of how the case should go, or, you know, of the route that, you know, what should happen. And I know that that's not necessarily what the child wants. So, and they have put their positions on the record, and I've said, you need to tell the court. You need to let the court know, are you using substituted judgment? If you are, you need to put it on the record. And that is my practice. If I'm using substituted judgment, Judge, this is what my child client wants. However, in exercise of substituted judgment, I believe that there's an imminent risk of harm to this child if I was to advocate what the child wants. Accordingly, this is what I believe should happen.
So the last question I have for you from Mr. Williams is, we heard from Ms. Layat about all the resources that she has as being an institutional provider. And as you as a solo practitioner, how do you get some of those same resources, social workers, investigators, to allow you to be able to do your job as a AFC?
Well, you know, credit to the Attorney for Child panel. The Attorney for Child panel does provide us with a range of services that we, you know, unfortunately, a lot of AFCs don't necessarily use these services, but the resources are there. Resources are available to us, and we can get a social worker. You know, we can get an investigator. The panel will pay for it. We just have to reach out to the panel, and those resources are there.
We're going to move on to Yusuf El
Ashmawy.
Thank you.
El Ashmawy.
No
So
problem.
you know what? So I want to make a brief observation, and sorry to say this, I'm not quite sure why the respondent, who was the subject of this case, is last. That's not good.
Isn't that fitting though? Isn't that fitting? No.
But let's talk about it.
You are child-centered.
You already went, Grace. Come on now.
So, but let's really talk about it. Is
Yes.
this because, you know, what we do in these Article 10s is say that the respondent is a bad person, and therefore we put you last. But let's not do that. Let's talk
Right.
about process, and
Right.
tell us what you believe as you're painting these pictures, or using that eraser to erase some of those strokes that were put on by the prosecution, by the AFC. What are you doing, and why you're doing it, and what do you see as your role?
Certainly, Your Honor. Many times it's more, it's a stronger, maybe turpentine than an eraser, depending on what's been depicted. But so I'm very grateful to be here, and I'm thankful to finish up strong. So to answer the court's question, in my view, you know, the role of the defense attorney is not just to come in and kick down doors and be enemies with everyone. You know, that is not effective representation. We live in an era where we have redefined many things. And, you know, the same sort of interdisciplinary concepts that have been alluded to by ACS, by Legal Aid, by Mr. Williams, they are present for the defense. And as a matter of fact, to talk about what that process is, the defense lawyer is just one hub. It's like a spoke in a wheel. The way that you begin to formulate an effective defense is to assemble a defense team. You need to, first off, assess thoroughly the allegations, meet with your client, speak honestly with your client, develop a rapport with them, make them understand that you are someone who can be trusted, make them understand that, the more free the communication is, the more that you understand, the more you can then in turn serve them and then serve everyone. It's unfortunate, and this is just as a brief aside, that, there's this concept that this has to be adversarial. And as a matter of fact, some of the most fulfilling experiences, as ferocious as I can be as a lawyer, and many people in the room can attest to that, my greatest experiences are the times where there is an agreement to something. And even that may be an agreement that my client would make an admission or a submission or take a plea or step away because the evidence is so incredibly strong. It's what's best, for the family overall, with a plan to reunite them in the future, right? There is no set outcome. So I say that to say, to go back to the court's opening remarks about, developing that rapport and learning. I had put together some materials that many of them were attached to what was provided to the CLE. And I made sort of a working outline, and my contact information is in the material. So please reach out to me. I didn't see it in there, but I'm happy to email it to everyone. But basically I have like a step process where I meet with clients and I sort of confer, develop the background, understand. And then, we start to set the strategy. And in order to set the strategy, these are very complex and dense cases. The law is complicated. The facts are complicated. Many times, as we heard from Ms. Oates, there's going to be an expert at least, or multiple experts. And from there, you start to put the pieces together and you start to figure out what you need to serve the client. I take umbrage at Ms. Obama-Layat's statements that, that the 18B panel, which I'm on, and I serve on the committee to put people on, and defense attorneys don't have access to the same sorts of resources. We do, and we use them. And I know I do because, and I put people on the panel and I inform them regularly that they have to use these things. We have everything available to us: investigators, social workers, experts. And, you're not doing your job after looking at that instrument and that petition, and you see that these are the types of allegations that are made, that you're not immediately consulting with experts, putting in 722C orders to get everything, social workers to attend conferences. This is what constitutes the defense team. Now, once you've sort of gotten your arms around that rapport and you feel like you have a working understanding of the case and you're beginning to put the pieces together, that's when you really have to level set. Right. And this is a very important thing. Many of us, I practice in the criminal system. I'm on the felony panel. I practice federal criminal defense. We know we have a concept of what the standards are, right? Everybody beyond the reasonable doubt, speedy trial. None of those things apply in family court. The standards, because there's a different consideration. So making clients understand that while your rights are protected, and you deserve, you're going to be heard and you're going to get a thorough and vigorous defense. This is about protecting children and also making sure that your rights are protected. But the primary focus of the family court is to ensure children are protected. So, of course, the defense's job is to raise that up and make sure that at the very least, it's being considered in the same level with protection of children, but making clients understand that the cases, what I like to say is it's a marathon. It's not a sprint. We're going to start out by understanding and prepare to be uncomfortable because, if you're representing a respondent who's excluded from their home, has their visits suspended or restricted to the point that they're, barely seeing their children, and they're fighting backwards, trying to regain access, but also defend, that can be a very, very difficult situation. I don't know if the court had any questions to interpose at the moment, but I can continue. With respect to making clients understand the law, I think actually someone mentioned, it may have been Your Honor, or another one of the colleagues stated, bright line rules. And, there's in the materials, there's a Court of Appeals case, the matter of F and C, which is, is a seminal case in our practice where the Court of Appeal says directly, this is an area of law that's not amenable to bright line rules. There's a lot of gray. You're dealing with very sensitive considerations, children, their safety. This is a very, very sensitive area to practice. So you have to make the clients understand that the nuances and developing, a successful strategy, and then adhering to that strategy and being realistic about what you could do and level setting is very important in developing the attorney-client relationship and getting to the right goal.
And I think that, as we look towards, setting that rapport, one of the particular cases that there's an issue is res ipsa locator. And could you tell the individuals that are listening what that is and how that will be impact on what defense you put on particularly a physical abuse case?
Yes, a nightmare, absolute nightmare. I mean, it's probably the most difficult aspect of case to defend. The doctrine of res ipsa loquitur is a civil doctrine because we have to step back and understand that family court is a hybrid of criminal and civil concepts. And although family court is civil in nature, it has some aspects of procedure that mirror the criminal system. But many of the concepts are actually civil and governed by CPLR and prior case law. The doctrine of res ipsa loquitur stands for, or means, the thing speaks for itself. And what that means is when you have a child, for example, perfect example, you have a baby who has a fractured femur and the baby is non-ambulatory and the parents are not able to explain whether it was accidental or inflicted and give a plausible reason for that injury, you are in res ipsa loquitur land. And the doctrine of res ipsa loquitur is brutal in many respects. I mean, from the defense perspective, it makes sense from the prosecution perspective because we're talking about the defense of children. But if you fall into the people who had dominion and control over the child in that, you are, by extension, as equally culpable as the other people in that. So when you deal with res ipsa loquitur cases, which are can be so exceptionally difficult, unless you have a clear explanation, one, you can refute the explanation or make the explanation given, which happens often. You have a client who says, and I've had this case, variations of this case. I had one where I had a client who was going to feed her baby and she dropped the baby from her arms and went to get her and pulled on her leg and the leg was fractured. They brought the child to the hospital and for some reason, the people in Harlem Hospital didn't believe that the story was plausible. And they said that the nature of the fracture was insufficient and it didn't match the injury. So they removed the child and all of the client's foster children and everybody else, and there began their saga. And so what do you have to do to defend that? The only way is to get an expert.
So it sounds like it's a burden shift. So the prosecution merely had to prove a fracture, and then the burden shifts to your client to then bring your expert.
Right. Yes. In essence, yes. And then, I'm sorry.
Go ahead. You had another thought?
Well, no, I was just going to say in that instance, the doctor came and testified from the hospital and we got a counter expert who explained that this was plausible and possible. And then the client and everyone in the home testified. And ultimately, this was in the context of a 1028 proceeding. It was found that Judge Pearl found that the injuries were consistent. They released the child home and ACS ultimately withdrew that case. And so it was a happy ending there. And the baby was fine, which is most important.
So once again, what we hear is that you painted a picture through the work. And that work was getting those investigators and getting those experts to support your claim that it didn't happen or it wasn't what the prosecution attempted to paint. Can you tell us how trial transcripts of your client's testimony can be used in criminal court if they can?
Right. So concurrent criminal proceedings are very common because of the nature and severity of what constitutes an abuse case. And normally they start both ways and starts with a police call. And then there's an ACS report, concurrent, and that's how that happens. When you're beginning with that theory of the case and developing, an understanding of your defense strategy, it's critical to understand, one, not only if a person's charged with a crime, but whether they're being investigated for a crime. Because, sometimes investigations don't automatically yield arrests or criminal charges. So anything that's said to police or in court, sworn testimony related to the substance of an abuse petition or abuse case could be used in criminal court. And I've had assistant district attorneys come on cases and sit in the back and watch hearings, waiting for that, wrong statement or for those words to come that lead them to say, okay, order those minutes because this is coming across the street. So yes, you have to be extremely careful about that. And I have had, several clients that despite those allegations, if they're prepared properly, they can still testify and do something in family court while not incriminating themselves. But yes, any statement could be used, and it's very, you have to be very careful.
Excuse me. My next question for you is visitation.
Right.
And you have a child that is out of the care and custody of your client. You've had months of supervised visitation. How are you asking for unsupervised, and how are you going to support that application before the judge?
Very difficult to get consent. I mean, it's fact driven. Let's start there. And as the court, and just so that as the court, I'm certain knows, and everyone here who practices regularly, there needs to be a sound and substantial basis in the record to support a decision regarding visitation during the pendency of an abuse case. What that means is, if it's not on consent and there has to be a motion or some form of litigation, you are supporting your application with client's testimony, service provide, the reports from ACS, the agency, service providers. You're referencing how the child is doing. Sometimes you'll have an AFC who comes and says, listen, my client really wants to have unsupervised visit. They don't want to visit in the agency during the pendency of the case. So that's going to be part of your application. You're making sure that that's somehow represented to the court. And in the aggregate, all of this information will, referenced against the allegations, will permit the court to have a sufficient record to make this very serious decision with these allegations. And there is a case, thanks to Celia, who the appellate lawyer found it, because I only found bad ones and she found the good one. But if anyone needs it, I'm happy to send. You have my email. I'll give you the citation is, of course, I can't see, in Ray Kayla C. That's a First Department case where on appeal, I assume by ACS, unfortunately, after unsupervised visits were granted to these individuals, I think it was two mothers, based on a showing that it was appropriate. The appellate division found that it was appropriate for exactly the reasons that I stated. There was a sound and substantial basis in the record that supported that.
So like I said earlier, this is a committed panel, and to practice in this area, you must be thoroughly committed in the due process rights of your client. You must do the individualized work to prove a case or to disprove a case. We must do our individualized work to protect our children. And as you see, the passion from each and one of these presenters is amazing. They clearly understand what their roles are. They clearly understand that they need to paint a picture for the court. They understand what proof is and how we protect our families as we move through this Article 10 process. Ms. Denman.
Thank you, Your Honor. At this time, we're going to state the CLE code, and then we will move on to our question and answers after Mr. El Ashmawy, if he would like to make some closing remarks. But first, we'll do the CLE code.
The second and final CLE code for this program is visitation. Visitation.
Thank you so much. My closing remarks are simply to say that, family court is a difficult place to practice, but I can tell you there is really nothing more rewarding professionally than my experiences there. There are a lot of hard things that you see, but if you go there with the right intention and you do the work, you get to really make an amazing impact on people's lives. So it's incredibly rewarding in that way. And two, reach out. You know, this is an area of law where we all rely on each other, you know, and we're not enemies, despite where we sit in the room and who's representing who. You know, professional relationships transcend a case. They should anyway. Some lawyers don't know that, but they should. And, you know, we all should be dealing with each other as colleagues and professionals and respect that everyone has a role. And yeah, I'm very happy to be here. Thanks.
Thank you. At this time, I will hand it over to Tanae McKinley Brooks and Asia Scarlett Jones to moderate the question and answer session.
Thank you so much. This was such a wonderful panel, and it just shows how much Article 10 plays a role in the lives of many people and how complex child abuse and neglect proceedings are. We have a chat question. It's the questioner asks, is it sufficient to rely on hospital records without calling physicians who treat the child? I'm going to ask that this question be answered by both Ms. Oates or responded to by both Ms. Oates and either Mr. El Ashmawy or Mr. Williams as respondents or adult counsel.
So is it sufficient? I don't think so. I think that if you have a medical record and you're going to need that expert to explain what's in the medical record, right? The court is not, we're not doctors, right? So we can't make up our own interpretations of what's written on this paper. Are there times when a medical record can be very, very clear about what happened to a child, what the injury is to a child, and what the medical findings were? Absolutely. But there are times, I don't think that it's necessarily sufficient to just rely on the record by itself, because as the presentment agency, you have to anticipate what the defenses are going to be as well. So opposing counsel is going to have someone come in and say, well, they didn't do this test, or they didn't, the medical professionals who saw this child didn't do this test, they didn't ask these questions of the parent, or you know, this this vitamin D level, or this this blood panel, these results could mean this instead of what your medical professional is saying in these records. So you're going to need someone to really explain that. So you don't want to just rely on the paper if you can help it.
Anything you'd like to add, Mr. Williams?
You know, I would say it depends, because, you know, there are certain instances where, you know, you have a record and you don't necessarily want a doctor to come on for, right? You know, you might not necessarily want the expert to go on the record for them to poke holes in his testimony. You know, the record sometimes speaks for itself, and sometimes if the record is so compelling, if the records are so compelling, you might want to leave it alone. So it's a call that you have to make, depending on the case, depending on the records. Sometimes you leave it alone. Sometimes, you know what, you want that expert to come in to bolster that record.
Or perhaps maybe if the child has decided to testify and the record perhaps corroborates the testimony. So I agree that perhaps maybe it depends. Mr. El Ashmawy, anything you'd like to add?
I don't think it's sufficient from the prosecution perspective. You know, I would be uncomfortable going forward with just records when I did that. I think you'd have to bring in, I mean, also, I think it's, I don't know, from a prosecution perspective, I think it's kind of offensive because, you know, the witnesses have the right to, the parents should have a right to confront the people that, you know, are giving evidence essentially. And that's part of ACS's case about, you know, asserting that they abused their children. From the defense side, I may not mind if they just put on records because that's it. I'm not dealing with a live person. And if I can find a way to rip the records to shreds and put on other witnesses that can talk around that, and I see Miss Oates shaking her head, then I might say, oh yeah, you know what, go ahead with the records, no problem. No. But yeah, I mean, I agree with Maurice's point. Like, you know, I may not want to correct that defect on the defense side. I may not want them to bring in the fancy polished expert with their resume and, you know, telling me, you know, oh, well, yeah, I wrote that's in the records, but that's not what I meant. What I meant was your, you know, client's guilty. So, yeah.
Thank you, Yusuf. I'm going to direct this next question to Tiffany, is also out of the chat. Is the parent entitled to a copy of the video of the interview made with the child at CAC?
So they're not inherently entitled to it, but the situation can go a few different ways. If the child comes to the CAC with a parent who is not accused of any of the abuse, so if there's a non-offending parent that comes with the child and the allegations are all against someone else, the team sits down with that parent after the interview and tells that parent what the child said. So they will know right then and there, you know, this is what your child has talked to us about, this is what your child has disclosed, this is what we think the next steps are. The video itself is maintained by, at least in New York City, Safe Horizon, which is the nonprofit organization responsible for sort of the mental health piece at the CACs. And we look at these videos as a bit of a hybrid between sort of a child's mental health type record and an aspect of a criminal investigation, neither of which a parent would be inherently just enabled to go and get. They do become discoverable during the proceeding. So during the family court proceeding or the criminal court proceeding, these are discoverable. A parent would be entitled to them in some way through that proceeding. We do typically seek out protective orders that say either that a copy not be given to them, but that they can watch the video, or if a copy is given to them, that they not be allowed to show it to anyone else or make additional copies. So typically, if they're getting an actual copy or watching a copy, it's because there's a court proceeding in some way.
Thank you. We have another question. If a court makes a finding of neglect based on res ipsa, is it proper for the court to require an admission from the respondent at the disposition stage? We'll have you, maybe Yusuf, if you could respond to that.
The court can't compel anyone to do or say anything, so they can't make them make an admission if people are denying it. What does happen though is that, and I've seen this happen unfortunately, is if a child is in foster care and there's been no progress on reunification and everyone who's been accused maintains that they didn't do it, and that will be a consistent barrier to reunification. And they will say, and I've seen it where a parent has done all manner of services. The agency and ACS will say there's no insight. Why is there no insight? There's no insight because no one has said what happened yet. We don't know what happened to this child. So I think the clearer way to put it, or the one that functionally makes the most sense within our practice, is it should be understood that if no clear explanation comes, that can be an endless barrier to reunification.
Is there anything you'd like to add, Maurice, to that response?
No, I think Yusuf did quite a bit of justice.
Great. Ms. Obama-Layat, you mentioned in your discussion that there are certain times when it may be difficult, or the decision to allow a child to testify, or when the child does not wish to go into the courtroom, is something that you confront as an attorney for the child. Does that sort of scenario impact settlement negotiations?
It certainly can. I have had cases where my client has not wanted to testify and has been willing to accept a settlement whereby, for example, the case will be brought down from an abuse to a neglect with certain orders that the child feels that they can live with. So that certainly can be part of the settlement, of any settlement.
Okay. And would that be an instance where if it is an abuse case that you would support, or you would support a neglect finding with an admission, as opposed to supporting an abuse finding in a situation where perhaps the evidence is compelling in favor of an abuse finding to prevent a trial?
If that is what my client's wish is, then that's what I would do.
Okay. Thank you. We have another question in the chat, and please feel free, anyone, any of the AFCs to chime in. How does an AFC know how to advocate for a pre-verbal child, example, less than 2 years old?
Thank you. I mean, I just take a look at the totality of the case. I read the petition. If there are other children who are older, they will inform my decision, because they can, we can discuss whether that child might be safe, if that child may have been put at risk at any time by the parent. Progress notes, I will read those just to get a sense of the parent. And, there are plenty of times when a nonverbal child can safely remain with a parent with services in the home. And so that is what I would advocate for if it were appropriate.
And to the extent that the decision is between a guardianship petition filed by a grandparent versus the child being placed in foster care for as long as a year.
In those types of instances, and depending on the child's age and the relationship that they may have previously had with a grandparent, I find it problematic, for example, if a child has been in foster care for more than a year in non-kinship foster care, and then a grandparent comes along, because my question is, where was the grandparent at the very beginning, at the inception of the case? And in the meantime, this child has developed a relationship with the foster family. And so depending on how bonded the child is to the foster family, and if they're able to articulate their wishes, I would either support or oppose a guardianship petition by a grandparent.
Thank you so much for that response. Anything you'd like to add, Mr. Williams, to that question?
No, I think counsel is 100% correct. To the extent that the child is not, again, we have to be guided by the rules of the chief judge. To the extent that the child is capable of knowing voluntary and considered judgment. If you have a child who's 2 years old, less than 2, who is not capable of articulating a position, then you obviously have to advocate based on what you believe is in this child's best interest. And you have to be guided by the totality of the circumstances, and that's how your advocacy would be put forward, zealously advocating for what you believe is in this child's best interest. Because again, the child's not capable of articulating, then you will have to, in that position, advocate zealously for the child.
Thank you. At this time, we will turn it over to Monique Hardy for closing remarks.
My apologies, a little technical difficulties. Well, Brian Tracy said it best when he said, continuous learning is the minimum requirement for success in any field. So we would like to express our appreciation to our panelists for this excellent, thought-provoking presentation this evening. I think we all can agree that this program was extremely informative and provided us with useful tools that we can incorporate into our own practices. We would also like to say a special thank you to our wonderful moderator, Judge Humphrey, and his facilitation of the discussion, which was a valuable contribution to today's program. We would also like to offer our sincere gratitude to Antasis Green and the rest of the MBBA board, as well as the Family Law Section E-Board for all of their support throughout this term. Additionally, we would like to thank the Family Law Section subcommittees, including the CLE Subcommittee and the Family Law Resource Directory Subcommittee for all of their efforts. And a special thank you to the Article 10 Subcommittee for providing such excellent programming, including our program this evening. Most importantly, thank you, the participants, for participating in our final program of the 2021-2022 term. Just to highlight some of what we were able to accomplish this year, the MBBA Family Law Section provided programming such as the Understanding Special Needs and the Law event that we co-hosted with the Second Department and Office of Attorney for Children, where we had key players in the field discussing the representation of special needs clients in family law. We also held the Family Law Symposium that we co-hosted with the Garden State Bar Association, which was a great success where practitioners from New York and New Jersey provided an overview of child welfare proceedings, as well as how to navigate the divorce process from pre-filing and post-commencement through the lens of cultural competency. In addition, the Family Law Section hosted informative general body meetings, where we had the great pleasure of having judges such as Judge Michelle Sweeting from New York County and Judge Cheryl Joseph from Suffolk County Supreme Court, providing great insight into being a jurist in these current times. The section also hosted an event with the Honorable Kathy E. Davidson, the Dean of the New York State Judicial Institute, where we discussed the importance of diversity in the profession and the new Pipeline Diversity Initiative that will expose high school students throughout the state to law school and the career opportunities available in the legal profession. Our deepest gratitude to all who worked tirelessly to ensure that these events were a success. We hope that if you had the pleasure of participating in our programs and reviewing the corresponding materials, it has served as a great resource as you continue in your respective practices. And if you have not already, please join the MBBA and the Family Law Section so that you too can provide ideas regarding the programming you would like to see and participate in its planning and development. The MBBA Family Law Section meets every first Wednesday of the month, so please go to the website on the screen to register. Thank you again to our panelists and our moderator and all of you for participating. Have a good evening.
Excellent job.
Thank you all.
Thank you. We have attendees leaving. Thank you so much. And thank you, Judge Humphrey. Thank you to all of the panelists.
Thank you so
I
much.
really appreciate it.
Such a great program.
I feel like
Thank you again for the invitation.
I don't think I conveyed myself.
Know where to get the CLE, where to send them to the CLE affirmation.
Oh, can you send the share the last slide, please, Monique?
Thank you.
Yeah, I will do that.
I apologize for cutting you off, Grace. People were asking.
Oh, yes, I apologize.
I'm sorry.
No, I think that I was misunderstood by the 18Bs when I said they don't have like the institutional support, because what I know is in our court proceedings, they're always requesting 722C or filing, 722C motions, which make it sound as though, they're not able to readily access